This case is in re estate of Richard Phillips. Each party will have 15 minutes to argue. The appellant may receive up to 15 minutes, or may reserve up to 5 minutes for rebuttal. How long would you like to reserve for rebuttal?
3 minutes.
3 minutes, okay. I'll keep track of that time. If you can't see it, I'll try to remind you when you get to about a minute left in your initial time that you're running out of your initial time if we get close to that.
Thank you, Judge.
You're welcome. Your arguments are being recorded. Please keep your voice up and remain behind the podium when you're speaking. You should not use the name of children, minors, and victims during your argument, although I don't think in this case that would be particularly relevant for you. If you would, you please refer to them by initials or the child or some other defined term like that. The judges have read your briefs and are ready to proceed when you are, so please, when you're ready, come forward.
Thank you.
Thank you.
Attorney Jones, on behalf of appellant. At times, something squeaks.
Everyone's looked out there. I kind of was wondering what you were looking at.
But I stepped on a snake for a minute. Anyway, construction of a will. If it is necessary, then construction of a will should occur. There is absolutely no necessity of any construction of any of the terms of this will. It really is the four corners, and there's no problem in understanding the four corners of this will. Testator, I want my grandson, and he's an adult, joyously, to receive $50,000 set aside for any college education that he might choose to proceed with. Completely clear. Completely clear also that I choose my trusted executrix to administer this estate. No doubt, that's the four corners of the will, those two items. Third four corner of the will, I direct if my grandson does not use all of the funds for college, the residuary beneficiaries, one of whom is the executrix and one of whom is another relative, will receive whatever is left over. There's nothing to construe.
Is it the issue that there's not a time frame to go to college?
We concede that. Absolutely.
So that is an issue.
That was an issue. That was an issue that they're going to have to move this. That was an issue that was brought up in objections by a prior attorney. Based upon what happened in the lower court, client chose a different attorney to represent the state's interest on appeal. That was the objection that was in fact filed, that gee whiz, it was too much time. But under the four corners of the will, the testator could have, if he had wished, chosen a limitation, but did not. It was open-ended, and on appeal, the executrix of the estate has conceded that it is for his lifetime. If it is used by him in his lifetime, great. If it's not used by him in his lifetime, bad. Or, yeah, he didn't get his education or didn't expend all the funds. But there is no reason why the court should have gone so far as to eliminate the residuary clause and believe that there was any construction of that necessary.
My first question, I guess, would be, is it your position the court should have just kept the estate open without having a trust as long as it took for the grandchild to go to school?
I would suggest that no. It could be either way, but it's the same thing. It will result in the same thing. If you keep the estate open, you're going to have you're going to have basic reporting periods that are continually bang, 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 bang. But if it was converted into a testamentary trust, because again, it could be looked at that way. But that doesn't make any difference. That doesn't mean that there's any reason to remove the executor.
So if there was a trust, your view is that the executor should have been the trustee?
Yes, sir.
Okay. So that's your objection as far as that goes. The executor should have been the trustee if there were to be a trust.
That is correct.
But that wasn't the objection made at the trial level. The objection was about the actual clause. You're saying that's no longer an issue?
The objection is by the other attorney who was handling it was time. That
right,
the child,
about the interpretation of that clause.
That's out the window.
So you're basically confirming that there was no objection about a creation of a testamentary trust.
That is correct, and that's why we have to get into the plain error doctrine. So that's where we're at. First, is it an error that is obvious? Absolutely. It's absolutely obvious. There was no reason at all to do anything that the lower court did. Leave the will alone, $50,000 sitting there, he makes an application, funds are expended for education. Is there a reasonable probability that the outcome would have been different if the error had not been done? Yeah, it's real easy. It's the terms of the will. It's exactly the will. There is nothing in this will that is not understandable. It is completely intelligible. And the attorney who is representing the estate below is also the one who drew the will. And again, if the testator had wanted it, and even in the conversations that are had between the court and the parties at the time of the motion hearing, it is admitted that, yeah, at times, I believe Mr. Brown, Attorney Brown indicated, yeah, I've had clients who put in time periods at some points of time. But again, that wasn't done. So it's a lifetime use of him. What we object to, though, is there a probability that that would have been a different outcome? Yes. Again, there is no reason to have construed the will to begin with in any way other than what the will was. The money should have just been left there, filed the annual account, move on with life until such time as either the beneficiary renounces the award to him, or he in fact expends all the funds or says, I'm done, I'm not going to be expending any more funds. So again, I would ask that this court do what the decedent is clearly indicating he wanted. It is plain error for the court below to have done that. It flies in the face of the direct, exact words of a competent testator indicating how he wanted his children and how he wanted his grandchildren benefit by the estate he left. Should the other attorney have made an objection about what we were talking about here today on appeal? Absolutely. I think that was sufficient to have not so done, and to object on that one limited item about the time period, because it, especially during those conversations with the attorney, when again it was revealed that certainly if you wanted to put in a timeline for it, you could have done it. You either do finish up at Ohio State by 1999 or whenever, and if you don't do that, then too bad for you. It's going to go to the residuary beneficiaries. What's happening here is the residuary beneficiaries are being completely dispossessed of any interest in an estate that was clearly directed. If there is $1 left over, residuary beneficiary 1 gets 50 cents, residuary beneficiary 2 gets 50 cents. This transmutes it where basically the primary beneficiary can just do nothing and wind up with the money turned over and then figure out who his relatives are that are going to get it. This is plain error. There's no reason.
I want to let that clear. I mean, I think you're referring to paragraph number 6 and 7 of the trust, where it says, in 6, if he attends college, then anything, as I read it, anything left over will go to his guardian, power of attorney or something, but it says under 7, if he does not attend college, then everything goes to the residuary beneficiaries. So it seemed to me to be a creation of a new term in there. If he goes to college and I take it some money's left, and you're concerned that whatever's left, if he goes to college, will go to his beneficiaries rather than the will beneficiaries?
No. Yeah, under this new construction that they've got going, it's going someplace else. Which is a clear violation of the terms of the will. And what happened, I mean, our business doesn't always result in justice. It doesn't. But when it's clear what someone wants, and that the justice is easily attainable by just following the words that were directed clearly in English language, then that should be granted as being.
And on the objections from the magistrate to the judge, was that issue raised that we are?
No.
Okay. I want to make sure. Thank you.
No.
And just so I understand, the objection here isn't really the creation of the trust. It's that the terms of the trust are not consistent with the intent of the will.
Correct. Yeah, I mean, you can't just go ahead and create a trust and all of a sudden change the beneficiaries, because that's what it's done. If there's any money left over, do what? Honor the dead. Honor what they want. That is justice. Not honoring what this man wanted before he died is not justice. He's clear. You don't use it all, whatever it is. You got some incentive. You know, by taking that incentive away and by redoing the will in whole cloth, the court has not done justice.
So
Thank you.
your brief doesn't talk about the standard of review. Would it be abuse of discretion and construction? If you're arguing that the
Well, it's abuse of discretion.
Okay.
Absolutely, yeah. It's abuse of discretion, and frankly, when you take a look at it, it's abuse of law. Because you're clearly denying a valid creation of a beneficiary of 50 grand if you go to college and use it up, and you're clearly denying, again, the law requires us to not construe wills that don't need to be construed. There was no construction necessary here at all. And that executive should not be removed. And another aunt of the college beneficiary be appointed. And then leaving it to God knows who later on. It's not right.
Thank you. You will have your full 3 minutes for rebuttal.
Good morning, Your Honors. Jim Amodio on behalf of the appellee, Joseph Slick. Your Honors, opposing counsel, may it please the court. We do have a dispute here as to whether the will needs construction, and I'll explain to you what the court did as a result of that. The first item of the testator's will, and I do want to mention that he was very generous by asking his executor to set aside the sum of $50,000 for my client in the hopes that he'd go to college. But the next sentence of that item is the one that is causing the problem here. It's pretty simple. If he does not attend college, this bequest shall lapse. That's all it says. The residuary clause, of course, comes into play, that's item 3, for anything that doesn't get disposed of by any of the prior items of the will. What the court did in this case was to construe that provision, because I disagree with Mr. Jones. I don't think it is clear as to what should happen. It's not really ambiguous, but it's also not clear. If he does not attend college, this bequest shall lapse. What the court did there, its ruling from December of 2022, said that if he does attend college, it doesn't lapse. And therefore, item 6, which the court pointed out before, of that original judgment entry, the same number in the final judgment entry that's being appealed from, said that if he attends college to whatever degree, 1 semester, a week, whatever it is, then the bequest does not lapse. That's the construction that the court gave to that provision. And therefore, it will just stay there until he decides to use it, or dies, or becomes disabled, in which case a guardian or a person acting under a power of attorney could utilize the funds for his benefit. Or if he dies, then it goes into his estate. And the appellant is saying, well, that disregards the residuary clause. It does not. It ties into the residuary clause. The very point of the residuary clause is whatever is left. And once Joey, it's called Joey, once Joey goes to college, the entire $50,000 is available for his use at any point, and becomes his if he passes away, goes into his estate. He can't just use it for anything else. He still has to use it for college. The court made that clear. And in number 7, of course, of that same entry, the court said if he doesn't go to college, it does indeed lapse, and all of it then goes to the executrix to share with her brother. And that's the ruling that the court made.
So your feeling would be under that, and under paragraph 6 and 7, if he goes to college for a semester,
Yes.
says, I don't like it, I'm not going back. And then that money still sits in the trust.
It does.
At the time he passes, or become disabled, or whatever might happen, then the trust would be terminated and the fund would go to him or to the residuary beneficiary.
To him. Well, not to him personally, because he's deceased at that point, but into his estate. Because again, it's a very simple clause. It should have been maybe a bit more elaborate, and I think the way Mr. Jones is interpreting it, it includes additional language, which I think violates the rule that we're all here for, which is to use the language of the will within the 4 corners, as he said, to determine what the will should say, what the testator intended it to say. And the only language is, if he doesn't attend college, his bequest shall lapse. If think the court made a very logical conclusion that if he does attend college, it doesn't lapse, and everything flows from there.
And this was all discussed before the magistrate below?
It was.
And there, again, there's no objection to that in any way, shape, or form?
Actually, Your Honor, there was objection during the discussion because Mr. Brown, the attorney at that time, was very clear, no, there has to be a time limit. We don't know what it is, we're gonna suggest 10 years. If he doesn't use it within 10 years, then that will have lapsed. What he didn't discuss is what if he used it a little bit during those 10 years and not, we never reached that point before the magistrate. The decision by the magistrate was actually taken pretty much on the court's own initiative. We didn't argue that, and neither did Mr. Brown. We were, at that point, as the court knows, the entire argument was is there an implied length of time to this bequest? The court said no, it could go on for as long, and we all know that people go back to college at very much advanced ages for a lot of different reasons. There's nothing wrong with that, and if the money was there, it should be used for that purpose. Which also ties into the reason why the court said, and in fact, the court said there should be a testamentary trust because the appellant filed a motion in August of 2022 asking for guidance. What kind of a testamentary trust do we have here? Because they knew they can't keep the estate open for 60, 70 or more years while Joey decides if he wants to go to college or not. Testamentary trust is the only thing that makes sense. And as far as who the trustee should be, not only, Your Honor, did they not say that they object to Marianne, my partner, Marianne Chandler, was a practicing attorney, by the way, also Joey's aunt, and was offering to serve without compensation, without bond or anything like that. When that was suggested at the hearing level, they agreed. It's noted in the magistrate's decision from December 13th, that all the parties agreed Marianne Chandler would be the appropriate trustee for this trust. So I do think on that basis that the provision, the rule that I cited in the brief that's found in, I think it's State v. Glarus, Supreme Court, and then Verisco v. Verisco from this court, that if you don't raise an objection at the trial court level at a time when it could be addressed and or corrected, you've waived it. So I think that they really can't argue at this point that Marianne is the wrong trustee, that part of the trust is pretty much set in stone because of the way this whole proceeding proceeded, I should say. And therefore, I think that for that reason alone, the executor should not be the trustee of this trust. But of course, there's another reason. She is one of only 2 people in the world that shouldn't be the trustee of this trust. Because she is one of 2 people in the world that will benefit if Joey never gets around to using that money. Or if she denies it on the basis of being, well, the trade school is not a college or whatever, and it's really a conflict of interest. So the court saw that and suggested somebody else, and we suggested Marianne. The appellant agreed, well, her attorney agreed at that time, Mr. Brown, that Marianne would be a fine trustee, and that's the basis for that particular part of the trust. But getting back to the other point. I didn't, and I apologize to the court for this, in my brief, page 22 of the brief contains an error, the appellee's brief. I wasn't focusing on paragraph 6 of the entry, I was looking at number 7, and arguing that the appellant's argument that the residuary clause was being ignored was wrong. It was in fact being honored by number 7, but it was being curtailed in number 6. And I should have addressed that point, but it wasn't clear in their brief of appellant that that was their argument. It wasn't until the reply brief, and of course once I saw their 2 or 3 page reply brief, it made a lot more sense, it all fell together, but they don't allow us to do a surreply brief to say, okay, now I understand. And on that basis also, I think the correct standard of review in this case is also a little different than abuse of discretion. Because I think it's pretty clear that when a trial court, a probate court, engages in a construction of a will, which it did here, on the provision as to whether the bequest lapses if Joey goes to college or not, when a court does that, that's then a matter of law. It's not a matter of the evidence or the witnesses or anything like that. And that's a de novo standard for the Court of Appeals. So we're asking you to look at what the court did and agree that it really made sense. I mean, it does. If you look at the language, it's so simple. If he goes to college, if he does not go to college, then it lapses. That's the only lapse provision that there is. If he goes to college, again, even if for a short time, but our hope, of course, is, and the appellant mentions this in their brief as well, that he have every incentive to go. If he goes even for a little bit, I think he'll realize it's a lot more involved and a lot more fun than he thought. He's not convinced of that just yet, but he's still young. He's only 19, and we have every hope that he will use the encouragement of his grandfather and the generosity of his grandfather to, in fact, go to college. But if he doesn't finish, if he doesn't get a degree, if he doesn't go for 4 years, it doesn't matter as long as he's made the effort and gone to college, then the course should not lapse. And again, he can't just use it for fun stuff. It's not his. It's his if he goes to college. Otherwise, it sits there until he decides maybe at an advanced stage he's going to go to college. But even if he doesn't, it goes into his estate because the lapsing provision is never activated. It's a very simple lapsing provision, which the court said can only be activated one way, which is if Joey never goes to college. Then the amount, $50,000, would go into the residual clause. So that's our position, and we would ask the court to uphold the judge's decision. I think it was a very well thought out decision and opinion, and as is embodied in the court's entry of April 15th, 2023, that the appeal was taken from. I don't know if I have any time left.
Yeah, we have time.
Okay, but really that's all we have to. That's all that I have to say. As I said, I think that the court has the ability to review what the trial court did on this construction issue and decide if that is correct as a matter of law. And again, we're limited to what is in the will. That provision does not say if Joey does not go to college, or if and to the extent he doesn't go to college. That would have been an idea that maybe so any leftover would go to the residue. I think the court was limited and is limited to the language in the will. And sure, we know that the grandfather wanted Joey to go to college.
So counsel, if Joey goes to college for 1 month and decides no, not going to college anymore, does that satisfy the?
I think so, Your Honor, and the reason I say that is that in order to go to college for a month, you have to enroll for at least a semester or a quarter.
Okay, a semester, a quarter.
Yeah, but you have to invest some time and some money into it. And he went to college. I mean, to go to college is a fairly vague term. You know, it's school after high school of a college level, university or college or an advanced trade school. So yes, I think if he goes, and that's what the court said. Again, we're talking about I don't call it punitive, but a rather drastic term, which is lapse. If you don't do something, then this will lapse.
And if he went for 1 semester, and then the trustee had liked the money, the trustee's obligation would be say, no, you're still able to go to college, I paid for your semester, and it will sit until
Correct.
you pass or you're incompetent, or some, whatever the factors are, number 6, it would seem to indicate it would lapse, or it would be determined at that point in time the money would be given to him.
That is correct. And again, because the money is sitting there for that sole purpose, he has every incentive to continue, even if it's not the next semester or the semester after that. At some point, it will click, hopefully, in him that a college education is a good thing. You learn a lot, and you also, get qualified for different types of employment. So the idea is, yes, it would just sit there if he doesn't use it. So, of course, it'd be earning interest, not a lot of interest, probably not going to be an account that's going to be handled by a professional investment advisor, but it'll accrue some interest to the extent he doesn't use it. And of course, if he doesn't touch it, that's when it goes to the executrix and her brother, which again is a good reason why the executrix would not be an appropriate person to dole this money out to Joey. She'd just be the wrong choice, and that's why the court said it should be somebody else.
And there is a provision, isn't there, that if Joey makes a voluntary decision in writing that he will not attend college and renunciates the trust proceeds, then that money would flow under, I assume, the residuary.
Again, Your Honor, we're talking about a situation where he renounces without ever having gone to college.
No, I'm not. I'm talking about, what if he makes a voluntary decision? He goes for that month and he says, nope, not going to college.
Okay. Again, I think at that point, Your Honor, the bequest is final. It's valid, and it can't lapse at that point, according to what the court said. And well, according to what the language that the testator uses, if he doesn't go to college, this bequest shall lapse. It's the only lapsing provision that there is. Therefore, if he goes to college, it doesn't lapse.
The trust will terminate though. It says that, the trust shall terminate upon the following events, and C is Joey's voluntary decision in writing to the trustee that he will not attend college and renunciation of the trust proceeds. That only means to not go to college at all.
I believe, yes. So he would have that right to do that, yes. Our hope, of course, and I think even the appellant's hope, is that that not happen, because that would, defeat the intention of the grandfather to use this money to go to college. And in fact, he has, I haven't talked to him a lot about this, but I know he's considered that. And he would like to keep and I believe he told the court this at the one hearing that we had, he'd like to keep the option open to go to college in the future. Because at that point, he was, I think, 18, maybe 17, and, realized that, he doesn't know everything yet. Maybe nobody does, but he would like to keep that option open. But yes, Your Honor, if he were to renounce it at this point, never having gone to college, the trust would terminate, and money would go into the residue of the estate to be dispersed that way.
Thank you, counsel. I notice your time is up. If you have a brief summary for the court.
Just the final summary, please uphold the decision of the trial court. I think it made a great deal of sense and does the best thing possible for Joe. Thank you.
Thank you. And counsel, you have your full 3 minutes for rebuttal.
Thank you, Judge. Clear language. I direct my executrix to set aside the sum of $50,000 to be used for the college education. To be used. That's only one thing that it can be used for. It can't be used for anything else. That's clear language. Now, if you would accept their premise that, oh, gee, it vested in, I mean, you can sign up, put down, I don't know what's it cost now, $12,000 for a semester or something, and attend English 101's first class at 8 a.m. and drop out at 9 a.m. When he goes to the registrar and says, I want my money back. That's not the intent of the testator. That is not the intent that they want you to accept.
But if that would have been challenged at the trial level in an objection, the court could have addressed that, right?
Yeah, they should have felt, yes, object.
Because then the judge, if there was an objection, then there could have been
Yeah,
a determination, but that was never made as an objection.
that's correct. Those were not contained in the objection. It was complained about a time period, but I mean, almost the time period is the same thing. So again, that's why, and I saw, their argument, and again, it's a plain error argument that we're making here, obviously. There was a failure here, and that failure should not fall upon the residuary beneficiaries. Again, if you accept their concept, though, and still stick with just the language that exists here, there would not have ever been a residuary clause. There would have never been a need for a residuary clause. There would have been no residuary. The will disposes of everything. Disposes of personal property, disposes of real property. Everything is disposed of. And there is no residuary, with the exception of this, that could ever exist, because everything else distributed. Every penny this guy had was taken care of. Every pencil he had in a drawer was taken care of. So the only thing that there could possibly be a residuary on is the lack of use of college money. And the directive is clear, to be used for college. And if he doesn't, the bequest shall lapse. I mean, if this is what he wanted, the testator could have just easily put in, if there wouldn't be a need for a residuary clause, and if he doesn't use it all, it'll be distributed to him or to blah, 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 whoever, whatever. But the fact that there is a residuary clause indicated the testator was contemplating there was the potential of a residuary, and the only potential of a residuary that exists in this will is this 50. There is no possibility for residuary on any other item that he had control or ownership over. So
I note your rebuttal time is up. You certainly may briefly conclude for us if you would like.
I would ask that the court would allow the will to stand, that there's no construction, $50,000 set aside, and he uses it for college, and God go with him. If If he doesn't, it's gonna fall into the residuary clause because there's no need for a residuary clause unless there's something left over that's not been expended on his college education. So there's no conflict in the will. Thank you.
Thank you. Thank you both for your consideration, or for your presentation today. The court will take the matter of environment and will issue a decision in due course. The clerk of court will mail that decision to you upon its release, and the opinion will also be released to the High Supreme Court website. The court is now adjourned.